Hello, I'm Rachel Arndt.
And I'm Andy Perkins.
And our next segment in our Q&A series is going to cover adoptions and guardianships and the differences between the two.
First of all, a little background in adoptions and guardianships. In general, both adoptions and guardianships are court proceedings that give some type of authority to someone over someone else. Both adoptions and guardianships allow for one or two people to be appointed the legal representatives or decision makers for someone else. Either adoptions and guardianships can be used for children or adults under the right circumstances. Both require petitions to the court, notice to other people, and a hearing in front of a judge.
Adoptions are designed to be permanent and generally irrevocable. Guardianships, there are two types. There are temporary guardianships, which generally do not exceed 60 days, and then there are permanent guardianships, which extend until either, in the case of a child, the child becomes emancipated, or upon either the parents or the guardians filing a petition to terminate the guardianship. Guardianships are meant to be reevaluated from time to time. Adoptions for children require proof of parental consent, and that's consent of the biological parents, either consent by them or a demonstration by the proposed adoptive parent that consent is not required. Guardianships require only notice, not necessarily consent. For adoptions, petitions are to be filed where the adoptive parents live or where the child resides. Sometimes adoptions are the result of a child in need of services case, in which situation then the petition for adoption would be filed in the county where that CHIN's petition is pending. Certain criminal convictions will disqualify a person from being able to adopt. Those are generally felony convictions that relate to the health and safety of a child. That also includes misdemeanors. What is required generally, besides the petition for adoption, is a home study. A medical history report is required to be filed before the adoption can be completed, and also a putative father registry search must be completed as well, and filed with the court so that the court knows that that is done. Then the clerk of the court and the state health department will issue a new birth certificate for the child that establishes the new parents.
There's a special kind of adoption called a step-parent adoption, and that occurs when the spouse of one natural parent or previous adoptive parent asks the court for that step-parent to become a permanent parent. This legally essentially replaces the prior natural parent. If the parent being replaced does not consent, the step-parent, who is the petitioner in front of the court, has to prove that consent is not required, because the natural parent has either not supported the child or not had meaningful contact with the child for 1 year. If a step-parent adoption is granted, the replaced parent's obligation to pay child support on a regular basis ends, but any back support that's owed remains. That does not go away. It also generally represents the end of any contact that the replaced parent is entitled to have with the child, essentially ending the legal parent-child relationship at that point. What are guardianships? Guardianships will require a petition to the court where the proposed guardian or proposed protected person resides. It's common that a guardianship may be required for an elderly person or a disabled person, someone legally unable to handle his or her financial or medical issues. This type of incapacity has to be shown by a physician's statement. Now, in the case of a guardianship for a minor, the fact that a person is under 18 is another type of incapacity, and so a physician's statement wouldn't be required to show that someone is a minor. So guardianships, once they begin, require that the guardian make periodic reports to the court about the assets, debts, income, and expenses involved in caring for the protected person.
Guardianships for children terminate when the child becomes 18 years of age, or in the case of a disabled child, the guardianship would go on either until the child's no longer incapacitated or until somebody has made a motion to terminate the guardianship. Guardianships for incapacitated adults continue until the adult becomes capacitated again, or for the rest of that person's life. A power of attorney is not a guardianship. Only the court can create a guardianship. Powers of attorney can generally be signed as long as they're notarized. A power of attorney may prevent the need for a future guardianship, but generally a guardianship will provide more protections for an incapacitated individual than a power of attorney could provide.
Thanks for watching this video. If you have other questions about guardianships or adoptions, you can contact us at the office at 574-223-4292. Thank you.